Katie Parks is here. Is Mr. Heminger there also?
He is not.
All right, I don't think he was here last time either. He lived there, but he wasn't here.
Randy does not live in the home. He was, we were divorced and the home was granted to myself.
All right, I'm not sure why I wrote that. What's the status here today, Mr. Reed?
Your Honor, I believe that the current balance without, which would include October, is $5,524 and court costs of $208.33 for a total of $5,732.33.
And Miss Lance. Do you own the mobile home?
I do not own it. It was a lease to own option, I believe.
All right. What's your response here, Miss Parks?
Wednesday, DHS emailed me their response. They're going to pay, I believe 700 and something. Neighborhoods Incorporated is still processing theirs, but they're going to pay the remaining balance. Up until October 1st, which would bring the total to just under 5,000.
All right, now the law requires that you pay the entire amount or you're subject to being evicted. These are, I don't want to use a non-legal term, these are unorthodox because it is a lease payment for the lot and a lease to own payment for the trailer. Normally, the funding agencies won't pay for the purchase price. I said this a little earlier. If you were buying a house in Centerville and your house payment was $800 a month, emergency funding does not pay your house payment. Even during COVID, it didn't pay your house payment. It paid rent. This is hard to discern rent from house payment. So if DHS or Neighborhood Inc. or anybody is going to pay it, then that's a blessing. But you have to pay the entire amount or you're still subject to being evicted. So you need to stay in contact with your manager and let them know what the deal is, because you could let's say they give you $5,000, you still owe $732 plus October's rent, plus on November 1st you're going to owe November's rent. The way this is pled, they can't tell the difference. It looks like all rent, and so if they're going to pay it, then I guess more power to you. One of the reasons why I allow these, I don't think we can even do this. I think it's supposed to be done as a just cause termination, but there's no hard and clear rule on it. So I allow these to go forward. And this is an example. If you can get financial assistance and maintain your housing, then everybody wins. Are you going to be able to start to pay the rent in November?
I do have the rent for well, not all of October. I only get paid bi-weekly. But I do have it. I just haven't submitted anything. Mostly because if I was going to be evicted, why?
You need it for the next place. Yes, right. I understand. All right. Well, do you have children there also?
I have 3 children, 12 and younger. I am also on a waiting list for an income-based apartment. Not really sure how long that is going to be.
For which apartment?
Income based out of Constantine.
All right, well, I find after hearing, I'm just gonna call this rent through October is 5,524. 208.33 in cost for a total of 5,732.33. I want you to share this with your funding sources, Neighborhood Inc., DHS. There's an order. You've got to pay this amount within 10 days, which would be October 23rd. Now, they don't have to evict you on October 23rd. What they're having the right to do is evict the trailer off the lot. And that's hard to do. So they can agree to work with you to try to get caught up on this for up to 56 days. So I want you to share this order with DHS and Neighborhood Inc. I want you to stay in contact with Ms. Lentz. Let me repeat, the only thing that'll cure this is paying the entire amount. But they can agree to work with you to get caught up on this. No money judgment is entered this time. Partial payment will not prevent the writ of eviction. And if there's additional rent due, for example, November, or there's damage to the unit, you could be responsible for that. But here's our figure through October, 5,732.33. You want to keep your kids there. You don't want to change school districts, everything that goes with it. So it's important you stay in contact with your manager and your funding agencies. Mr. Reed, do you have anything to add?
No, Your Honor, you received the judgment that we had sent over.
I do, and I do greatly appreciate that. We're going to send that to you immediately, Ms. Parks, and you share it with your funding agency. All right, you're good to go. Thank you.
Thank you, Your Honor.
All right, see you next time.
All right.
All right, I've got our next case. Mr. Thornton is here on behalf of Sturgis Place Apartments. Their management is here. And we got Brandon Adams and Ashley Parks. This is a second hearing. Let me make my notes here. This was set for 2:15, which makes us 16 minutes behind. Again, all things considered, it could have been worse. We were here last time. The defendants had contacted Neighborhoods Inc. They had paid some, and we continued the matter. Mr. Thornton provides these judgment informations, which are very helpful. Mr. Thornton, what's the current status?
The judgment information sheet I provided today that lists the rent and late fees at $3,832.66. And then
Just a minute, did I get a new one?
You should have.
There it is.
It's marked revised 10/13 of 2025.
Got it, thanks.
So those numbers on that sheet are accurate to my knowledge.
All right, Mr. Adams and Ms. Parks, what's your position?
I've tried everything I possibly could to get any kind of assistance. So every program out there I've tried, and I can't get any help because the rent's too high here. So yeah, I don't know what to do at this point.
All right, it is one of the higher rent units in the county. There are some houses in Three Rivers now that charge more than this, but I think this is the most expensive housing, rental apartment housing in the county. Maybe because it's nicer than everything else, but generally they won't fund that. You're paying $1,400 a month in rent plus late fees each month. So what is going to happen is you're going to have to move within 10 days or you're subject to being evicted. Let me look at my judgment here. the funding agencies were out of money. And then October 1st came and Ms. Bauer met with them at the housing symposium a couple of weeks ago, and I guess they've got more funding, but they aren't probably going to pay for this. This isn't the first time I've heard this, that this is too expensive for them to pay. So through October 2025, your rent is $3,832.66. Utilities and renters insurance for $117.89. And the costs are $237.40. Total $4,187.95. Now, the law says you have 10 days from today to pay the rent or be subject to being evicted. That would be October 23rd, 25. Now, this didn't sneak up on you. They've been working on this for months. Rent hasn't been paid in full since August. The notice to quit was served some time ago. And this is the sad end of the whole landlord-tenant process. If people are unable to pay the rent, they are compelled to move. And if they don't move, the sheriff comes and puts their stuff out. The defendant may be liable for money damages after moving if additional rent is owed or there's damage to the property. Acceptance of partial payment of the total amount will not prevent a writ of eviction. And no money judgment is entered at this time. You also have 10 days till October 23rd to appeal this. Now, when you do move, the law says you're supposed to turn in your keys and give your forwarding address in writing within 4 days of your moving. That triggers the security deposit law. Now, even though rent is expensive, this complex has a waiting list, just like everybody else. They got people waiting to rent your apartment. We've got some new housing in Centerville. I think there were 9. I think there are now 15 units of 6. And those are about $1,100 a month, and they're unsubsidized. So 15 times 6 is 90. There's 90 to 100 units in that complex. And they've got a waiting list of people that wish to move there at $1,100 a month. The problem, however, it makes it sound easy. Well, move somewhere else. Almost everybody I talked to would move if they had somewhere to move to. There is a waiting list, certainly for all the income-based housing. Every single one of them are full, and they have a waiting list. And there's not much in the way of emergency financial assistance. So people are struggling. By the same token, the landlord has to pay their payment, and they've got people ready and willing to rent the apartment that can afford it. So it's a tough circumstance, and I do it multiple times every week. Don't take any joy in it, but you got 10 days to move or you're subject to being evicted. You need to stay in contact with your landlord and let them know what your intentions are. They don't have to evict you on the very next day, which would be October 24th. They can agree to work with you to get caught up on it, but I don't think that's going to happen. And so if you don't move, they might lose November's rent, just probably not any more than that. But the sooner you move, the sooner they can clean the apartment and re-rent it. So once again, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. Do you have any questions?
The only question I have, should we talk to management about getting maybe some of the rent knocked down for situations that have happened here?
Yes, now, once you move, if you do move, and they sue you for money damages, those damages could be offset. Let's say that your water didn't work or your stove didn't work or other issues. Those could be abatement issues where rent would be reduced. But yes, could discuss that with them.
Okay.
All right, that perked Meg's ears up. Meg, do you have a input?
I was just thinking if this was a redemption amount, that sounds like a tribal issue to me, that's all. But
Well,
I also
they raised
thought
it
that
at
if
the 59th minute of the 11th hour.
Yeah.
Oh, by the way, in the vaguest of terms. Yes, you can discuss that with your management, but you should be prepared to move. If there's a complaint for money damages, we will certainly consider any abatement issues.
And I thought if I popped on, it might subtly suggest that if they do get sued, they could contact my office.
You hear that? If you
Yes.
do get sued, you contact legal aid and they can assist you with those issues. All right, thank you. Mr. Thornton, you didn't have to say much. You put everything in writing for me. Anything you wish to add?
No, Your Honor.
All right, thank you. I'll
Thank
see you
you.
in 2026, okay?
Okay,
I'll see you on Wednesday, actually.
sure.
But,
Yes, you will.
all right, thank you. Okay. I'm going to address this matter. It's entitled Becky Cup versus Brooklyn Holly and Brooklyn's Balanced Training. File number is 251652. Becky Cup is here at the conference room in the courthouse and Brooklyn Holly is here by Zoom. This is not a hearing on the small claims. It's a hearing on Brooklyn Holly's request to set aside the default. Ms. Cup filed this lawsuit asking for these money damages having to do with the training or dissatisfied training of her dog. The matter was served on the defendant. I had all kinds of documentation, pictures, screen captures, text messages, and I was prepared to have a hearing in the matter. Ms. Cup showed up here at the courthouse on the scheduled date, September 15th. She was here and I placed her under oath and she testified about this claim and I gave her what she requested, $1,800 by default. You don't have to come to a to a civil case. If you don't come, you're not in contempt, but if you don't come, you automatically lose and a judgment enters on the other side. So that's what happened. In fact, I took the extra step of having Ms. Cup testify a little bit about what was what. And I entered a judgment on her behalf. That was on September 15th. 4 days later, after apparently she got the order, Ms. Holly wrote a letter to the court on a piece of paper. It wasn't exactly a motion to set aside a default, but this is small claims court after all. In order to set aside a default, Ms. Holly, generally in a civil case, you need two things. You need a meritorious defense, and you're supposed to file what's called an affidavit of meritorious defense. Again, we're in small claims court. You speak to some of your defenses, but the other thing you have to have is a legitimate reason for failing to appear. Like I was in the hospital or I had a car accident on the way there. Generally, I forgot is not a good reason to set aside a default. Ms. Cup took the day off. She came over here. She brought a friend with her. She was placed under oath. She testified. She thought she prevailed. And then 4 days later, you say, oh, wait a minute, I forgot to come. Can I have my hearing now? generally, that's not a reason to set aside a default. I missed my small claims hearing. This is completely my fault and error. I had the date saved in my calendar as well as I took off work to be at my hearing. I thought it was the 18th and said it was the 15th. Called in later and realized that you had missed the hearing. Is there anything more that I need to know?
No, I'm not gonna make up an excuse or anything like that. I completely was my fault. I put it in my calendar wrong when I got the paper and we moved and I didn't have the paper, so it was completely my fault. I'm not gonna make an excuse for it.
All right, I respect that. So I don't know whether I expected to have about a 2-hour long hearing about dog training, but that isn't legitimate reason to just say I forgot. If this was a general civil case, there would be more to it. So I'm going to allow the default to stand. Maybe you had a case. I had a gentleman the other day who was very upset, and I kind of lost my temper. I feel bad about it. He didn't show up and he got defaulted. And he actually got double dipped. The people got the property and they had to pay them for the property. But he didn't show up for the hearing and he didn't have a good reason why he didn't.
Right.
So the judgment stands.
Okay. That's totally fine. I just was trying. I had called the court and I wrote the
Well,
letter.
I could have
the
just
same day.
denied it, but I thought I would at least talk to you face to face and maybe there was something I didn't know.
Yep. I'm not gonna make
you
an
owe-
excuse for it.
All right, well, like your daughter was sick or you had to cut yourself or something, but I respect your candor. You owe her $1,800 plus 86.25. You owe $1,886.25. One thing we could do at this hearing, can you make some sort of monthly payment on that?
Yeah, I was actually going to ask, Your Honor, if you don't mind, I need contact information for Mrs. Cup, as I did message her after the last hearing just to let her know that I was going to try to get the set aside done, just because that's what the lady on the phone told me at the courthouse when I called. She just said get a letter here today, and I was like, okay, I'll do that. But I didn't receive a text back, so I want to make sure that I have the proper contact information,
Well,
and then yes, I can
is
set up a payment.
the Warren Road address in Mendon still correct? Ms. Cup?
No, Wakeman Road.
Oh, yeah, we spelled it wrong. It's Wakeman Road. There's no Warren Road. Yeah, it's Wakeman. Our order says Warren. Miss Holly, can you make some sort of a monthly payment?
Yes,
How
absolutely.
much can you pay each month?
Would she be okay with weekly? I can do $50 a week minimum.
50 a week would be 200 a month, which is what I was thinking. Miss Cup, is $50 a week acceptable?
Yes. Yes.
Okay. Minimum. I'm not saying that's what it's going to be every week, but that would be a minimum point.
All right, I can amend this. So we're to $50 per week starting November 15th. And we'll change this to Wakeman Road.
And how should I go about making those payments back to her? Or
Well, I don't know. We could do Venmo or
Okay.
something. What I normally
Right.
recommend is people send a certified check. I don't know if she's willing to give you her Venmo information. Ms. Cup, are you willing to share that?
I don't have Venmo. I don't do any.
would you be okay with maybe like I could bring you cash. I don't know how that would work with the
Well,
court
if you bring
situation.
cash, you need to make sure you get a receipt. I always
Yes.
recommend postal money order or certified check.
Okay. Okay, I will, if your number is still the same, I will text you after this and try to come up with a plan for payment.
All right, very good. Ms. Cup, if you go out to the counter, we'll get you a corrected copy of this. I've amended it to show $50 a week installments starting November 15th. All right, Ms. Holly, thank you for being here, and I'm sorry that it turned out the
Okay.
way it did, but I respect your candor.
Yep, it's okay. I just thought I'd try. Thank you.
All right. All right, Ms. Cup, you go out to the counter and we'll get a corrected copy of that with the new information.
Okay. Thank
Do you have Ms. Holly's contact information?
Yeah, I still have it.
All right, very good. Anyway, we're gonna need to change, just a minute, is Kim here?
She's not.
All right, we're gonna need to change this order. Need to say Wakeman Road,
Okay.
and the amount is the same, but we're gonna add $50 a week installments.
Okay.
All right, thanks. This is your park, Memory Lane Mobile Home Park versus Alyssa Blizzard. The file number is 251918. Your manager, Chris Corpening, is here. Attorney Stuart Weiner is here, and Meg Bauer is here from Legal Aid. You're a tenant in a landlord-tenant proceeding. We may need to break this down a little bit. They're alleging that you're behind on your lot rent and the payment toward the purchase of your trailer.
Yeah.
Ms. Blizzard, could you turn your camera on? All right. This was filed as a demand for non-payment of rent. The complaint says rent's $560, but that doesn't tell the whole story. Because there's a payment. So Mr. Weiner or Ms. Corpening, could you break down the current arrears for me?
I can do that for Ms. Blizzard. So she has to pay a lot rent, a home payment because she's purchasing her home, and there's a $50 late fee.
All right, how
So-
much is the home fee?
The home fee is $165 a month. And the lot fee had been $530, but then it went up in May to $560.
All right, and the pleadings only show the $560. They don't show the payment. So
Yeah.
what's the current arrearage?
The current arrearage was, when we filed the complaint, was $2,295. However, she then did not pay September and October. So there's $775 for September, $775 for October. That then gave us a total of $3,845. And then there are court costs. I get the statutory attorney fees of $75. There were service fees on process of $51.20. And then there was a filing fee of $130. The total number and amount of costs is $256.20. So if I add the rent and the costs, the total amount of the judgment I am seeking is $4,101.20.
All right, Ms. Blizzard, they're indicating that through October, you owe that much in rent and lot payments and I guess a couple of late fees. What's your response to that?
So I went to Neighborhoods Inc. and they've agreed to help get me caught back up. On Friday they said that she just had to somehow get the paperwork to the landlord, and she said that that was on Thursday. She said she would be in Sturgis at some point to drop those papers off to her. But I didn't hear anything back.
It may take a while to accomplish this. But I think we can adjourn 1 week. The law requires a 1 week adjournment. It sounds like you're well in the process. Next Monday would be the 20th. Let's look at that date. I had it up and then I look for something else.
20th works for me, Your Honor.
Let's see what we got. We got a busy afternoon is what we got. 115, 120, 210, 215. 220 on October 20th.
Okay. Chris, does that work for you?
Yes, it does.
Miss Blizzard, nothing terrible is gonna happen on the 20th. In fact, you'd get 10 additional days from that day to pay the rent, or you'd be subject to being evicted. We could even continue it if the rent was in the works. Now, let me tell you something that you need to know. The only thing that will cure this is paying the entire amount. So let's say Neighborhood Inc. gives you $3,000. You would still need to pay the balance to bring it to 4,101 to prevent the writ of eviction. The landlord can always agree to work with you, but sometimes they pay much of it, but not all of it. Now, you can share this information with Neighborhoods Inc. The amount is 4,101.20. It's gone up since the summons was served because 2 additional months have passed. Are you employed?
I just recently switched jobs. And I do have some, like, a partial amount of what I owe right now. I wasn't sure how that whole thing worked, if you're supposed, because I've heard you're not supposed to pay rent.
As much as they give you, you're responsible for the balance. Of course, then on November 1st, November's rent is due. But this is more than just a lot rental. You're actually buying the trailer.
Yeah.
So I'm not sure whether they'll pay the cost of you to purchase the trailer. They may pay the lot rent, but not the purchase rent. For example, if I was buying a house and I was behind on my house payment, Neighborhood Inc. wouldn't give me my house payment. They'll pay rent, but they won't pay a house payment. So I'm not sure how much of this, how it all breaks out, but hopefully they'll give you enough money that you can maintain your tenancy. So we'll revisit this next Monday, the 20th of October at 2:20. Does that work for you?
Yeah, that's fine.
All right, you did a good job of logging in. I'll see you at that time. You should get a new notice. Share this information with Neighborhoods Inc. Okay?
Okay.
All right, you're good to go. Gardner and Caleb Applegate. I think this is the same situation we had last time. Some of it is lot rent and some of it is payment toward the purchase of the trailer. Mr. Weiner, what's the status here?
So as of the time that we filed the complaint, which was in August of 2025, Caleb owed $3,075. That consisted of a lot rent of $560, a home purchase of $415, and a late fee. Because June, July, and August was also not paid, that increased the amount by $1,025 for September and $1,025 for October, or a total amount of rent and fees of $5,125. In addition, costs consisting of attorney fees, statutory $75, a service fee of $51.20, and a filing fee for the complaint of $130, added $256.20. So Caleb now owns $5,381.20.
Is there a separate service cost on Haley Gardner?
Haley Gardner is not before me today. Haley is with Caleb. No, this is for both of them.
All right. And again, give me the lot rent and the trailer payment again.
The lot is $560 a month. The home is $415 a month. The late fee is $50.
All right. Mr. Applegate and Ms. Gardner, do you agree with those figures?
Yes.
Have you asked for any emergency help?
I did. I don't remember which one.
Well, what does that mean?
The one that you I texted them, but I didn't get anywhere.
All right. Well, do you guys have a plan to try to catch up on this, or do you plan to move?
We would like to work something out in terms of making payments, but there's also other situations with the living that we would like to get figured out.
And what's that?
Um, there's several situations with the trailer. One, there's a large black mold section that we're told would be fixed and has not been fixed. On top of that, we have not been given a mailbox key to our mailbox in the time that we've lived here. Whether we've been to the post office or the office themselves, we have not been able to access our mailbox.
That's been an issue at some other parks as well. All right. Well, so there may be an abatement issue, but you haven't paid rent in months and months. And you sort of did a half-hearted attempt to get some emergency help. You're buying the house, you'd lose whatever equity you had in it. You'd lose your ability to stay there and you'd be compelled to move out. So, and in order to actually, there's a way to not pay your rent, pay it into escrow. Nobody ever does it right. But you could pay the rent to me if we're gonna get into an abatement issue. But the law requires that we adjourn this matter at least 7 days. Are you gonna ask for any additional help?
Yes, yeah, I've been seeking help through family and other situations through MDA.
Are you guys employed?
Yes. Well,
Where do
I
you
am.
work?
I was in the Navy previously, but due to the situations in the government at the moment, I am home working at Myers right now.
Where are you working now?
Myers, yeah.
Okay. Well, if you were in the Navy, you'd not be getting paid right now.
Yes,
So
yes,
there's
yeah.
a terrible state of affairs. All right, well, I'm gonna adjourn this matter to 2:30 on next Monday, which will be 10/20/25. In the meantime, I would suggest that you touch base with Ms. Corpening and you also look into these additional funding agencies, Neighborhood Inc., Community Action Agency. Haley didn't even know which agency she asked for help on. You need to be a little more focused than that because they may have some money to help you get caught up on your rent. If that happens, we could always continue the case. But continuing where we are right now, if they get what they ask for, when I meet with you on October 20th, I will tell you have 10 days to move or you're subject to being evicted. And you would be evicted on the 30th of October and the sheriff would come put all your stuff out in the street. That's not a good position to be in. So you need to go to these funding agencies, stay in contact with your landlord. This mold issue, we're gonna deal with it. For one thing, you're buying it. At some point, once you bought it, I guess it would be your problem. Now you're purchasing it. That's an issue that may need to be addressed. And legal aid is here if you wish to consult with them regarding that. Would you like to talk to the attorney from legal aid?
That would be great, Your Honor.
All right. Anyway, talk to the funding agencies and stay in contact with your landlord.
Yes, Your Honor.
How do we go about getting our mailbox key?
Yes, another issue. That's been an issue. I had a park the other day and they've been there for a year and they couldn't get a mailbox key.
Your Honor,
Chris, could you look into that?
yes, they have to go pick it up at the post office. I don't have anything to do with them, with the mailbox keys themselves. They just pick it up at the post office.
We
In
have been,
Sturgis?
Yes, in Sturgis.
All right.
I'll be happy to
Click-
email them and find out if they've done anything, because all I do is once they sign the paperwork here, I email the post office and they come out and change the box, and then they have to go to the post office and pick it up. I'll be happy to email them back and find out if that's been done.
All right, thank you.
You're welcome.
Click on the button that says join.
Thank you, Judge.
Thank you. All right, Miss Bidwell, can you hear me?
yes,
All right, we went through your rights. Your case is similar, but you own the trailer, all right? So this is lot only. And back up here a little bit. Mr. Wiener's office has provided a court breakdown, and I greatly appreciate those. Rent is $560 with a $50 late fee. The time of filing, it was May, June, July, and August. Ms. Bidwell, I can't talk to you while your vehicle is moving, particularly if you're driving. I'm not gonna do this court hearing while you're driving a car. It's a recipe for disaster. So I'm gonna turn this off. I want you to pull over. You started driving while we were dealing with this.
I apologize. I'm on my way to a job interview, but I can pull over really quick.
Well, yes, you need to do that. I don't want to have an accident. I'm gonna put
Okay.
you in the waiting room. People treat court as an inconvenient nuisance, which it certainly is, but appearing by Zoom is a gift. And some people, one of these days, someone's gonna have a crash while I'm talking to them. Mr. Wiener, I do appreciate these court breakdowns. John Bush always did those for memory lanes, and they're very helpful to me.
You're welcome, Your Honor. I think it helps everyone to
It
understand.
speeds the process up. All right, now I've got people in the waiting room. I want to bring them all in.
Up, she's back.
Hey,
All
sorry
right,
about that.
All right, I don't want to have an accident. All right, in this case, we're going through this, May, June, and July, and August. Has anything been paid in September or October?
No, well, I don't believe so.
All right, so it would be 610 times 3.
Right, well, there's another 2, so she paid,
Oh, times 2, yeah,
yeah, so she had
610.
not paid May, June, July, August. That was $2,240. Then September and October, that's another $1,220 with the late fees of $300. That number became $3,660. In addition to that, she owes attorney fees of $75, service
minute.
process.
2240, 610, 560 plus 50 is 610. So
Yes,
I
I'm
added,
sorry, 610, yes.
all right, that becomes 1220. If we
Correct.
add 2240 plus 1220, we get 3460. I think you said 3640.
Yeah, that may have been a math error on my part. Well, you know
All
what?
right.
No, it was 2440 plus
2240.
2240. Oh, you know what? Chris, on the complaint, I said 2440. So there was another $200. Do you know?
That is the court.
Oh, those were
That's the late
probably
fees.
late fees.
Yes.
Those were late
Mhm.
fees.
All right, plus 200 in late.
That's why.
All right,
So then the total is
36.
3,660. And then we
All
have
right.
attorney fees of 75. service of process fees of $51.20, and filing fees of $130, for a total of costs of $256.20. And then if you add up the total rent, the total costs, I get $3,916.20.
All right, Miss Bidwell, what's your position?
I moved out and I tried to come to agreements with her. I've tried to sell my trailer, and at first she didn't approve. And I do have somebody that's going to buy my trailer for the back rent that I owe, but she won't approve them. I don't know how I was supposed to pay where I live now, like where I've been living, and be able to pay the back rent of the trailer. And
when did you move out?
I believe it was May or June.
May or June?
Yes.
All right, when you move out, you're supposed to turn in your keys and give your forwarding address in writing within 4 days of your moving. Did you give notice in writing to your landlord that you had moved?
No, I told her that I moved though.
Did you give her your forwarding address?
No.
Did you give her your keys?
No.
So is all your stuff out of the trailer?
Yes, it is. There's some garbage there. It needs cleaned out from my sister staying there. But yeah, all my stuff is out. I've tried to give Chris the trailer. She told me that she wasn't gonna give me anything for it and whatever. She was rude about it at first, and I've been trying to come to agreement since then with her, and it's really hard.
All right,
It's really hard with her.
How long was your sister in there after you moved out?
About a month.
All right.
And she absolutely
this
destroyed it.
Sister destroyed it? Oh, great. Well, this would give them the permission to remove your trailer. This is lot only, which theoretically, I'm not even sure you can do it this way, but I've been allowing it. Some judges don't allow the mobile home parks to do this, but I do it because it lets the tenant redeem it. So you moved out, you didn't give her your forwarding address, you didn't give her the keys, your sister moved in, trashed the place. Now they've got this trash trailer on their lot that probably doesn't have much value. What year is it, do you know?
I think it was a 97.
All right, Mr. Weiner, you got any ideas here?
No, a lot of these facts are new to me. Chris, anything that
Your Honor, I am working with a lady who wants to purchase her home, and I have explained to her that the past due rent has to be paid before the purchase can happen. It's not that I have not approved her, but I want to know what's going to happen with the past rent. Katie did not tell me she was moving, and I did tell her that we would possibly be interested in it for the back rent about 2 months ago, but I needed to see the inside of the house, but she tells me she can't be here. I really am trying.
All right, we're going to continue this to 2:35. Next Monday, October 20th. There's several issues.
Okay.
Yes, go ahead.
I start a new job on Monday, and I don't get out until 3:30.
All right, well, if you don't come, you'll be subject to default. I would suggest that you do get a hold of Ms. Corpening and discuss these issues. Perhaps something could be done, but we do court at certain times of the day. I hope you do good on your job interview today.
Thank
But, that's when it is, next Monday at 2:35. So you might need to take a break for a minute from work to zoom in. But, and contact your landlord. Maybe they can work out the transfer of this property and we can close this out, but you didn't exactly follow the law when you just sort of left and let your sister trash the place. All right. I'll see you hopefully next Monday at 2:35. All right,
Okay.
thank you.
Thank you.
Thank you, Your Honor. Thank you,
I
Stuart.
think we're done, Your Honor.
All right, thank you.
We'll see you next
All
week.
right. Now we've got some other matters. We've got one more landlord tenant matter before we address our civil 145 matters. And that is Hagel-Gans. Let me find that. What did I do with it? Here it is. All right, this one is entitled Doug Hagel-Gans versus Kaylee Henderson. This is a property on Middle Colon Road. Kaylee Henderson is not here as far as I can tell. Mr. Hagel-Gans is here in the court conference room. This is filed as a termination of tenancy. Mr. Hagel-Gans wants her to move. Mr. Hagel-Gans, is she still there?
No.
She's left?
Yeah, about 2.5 weeks ago.
All right, she's not here, so she's subject to default. I will find that the plaintiff has a right to possession of the premises. I'm gonna put 10 days from today, which would be October 23rd.
Sir,
But plaintiff, if defendant has vacated, plaintiff may have immediate possession.
Sir, it was her and her boyfriend. And a little.
Is he still there?
Pardon?
Is he still there?
No. But he's working and she's not. And I'm assuming that I gotta file small claims papers. And,
Yes, now you have no lease. It's
Pardon?
not wise to be a landlord and not have a lease.
Well, it wasn't exactly a landlord. They were homeless.
That's what I understand. So now they're homeless, you don't have a lease, but now you want to sue them. Well, you can sue them, you may not be able to collect any money.
Well, the only thing I want to sue them for is everything they busted at the house. I mean,
All right, well, you could certainly do that. I would suggest you not rent this again until you get a lease. It'd save you a lot of grief.
Well, I'll never have anybody else in there again in my life. I'm not letting my things go like that.
Well, let me tell you what I just did. No one appeared on behalf of the defendants. They were, what were they served?
You get immediate possession of stuff.
They don't have anything in the house anymore, but they've got a ton of stuff outside, including a 40-some foot motorhome sitting in my side yard.
Oh, boy.
And I got already, last, what was April 14th, the township got on me and I had to pay $264 to the township. And they were supposed to get it out of there. And they never.
All right, well, this, they've never been served with this. With this lawsuit.
what we're here today for?
Yes.
They were served twice.
Received papers for court service. Called Doug Hagelgans to discuss service and request payment. Called Doug,
Yes.
left message, said he would call me the first of the next week. Called Doug Hagelgans, no answer, left message. Doug called when I spoke to him, he advised he had had enough of the defendants, told him they had to move right away. Changed the locks on the house, advised they were not happy, but moved everything outside. They have other items in the yard. He has called the township ordinance enforcement on what to do. He did not want paper served as he said they got it in the mail. He advised to explain everything at the hearing with the judge. This case is dismissed. They're now served with the lawsuit. If you want to sue them in small claims court, you can for money damages, but there's no cause of action to terminate their tenancy. They've already moved.
Right, I understand that. That's why I didn't have Mr. Morris serve papers, because they were already out of the house. And I
All
didn't
right, so
pay
you
him.
don't have a case. You
Pardon?
have to tell them that they're being sued. They've never been served with the lawsuit. So this case is dismissed.
Well, I'm not understanding, I guess. They're already out of the house, and that's what I wanted. But
All
now
right.
I know what to do with all their junk.
Well, that's your problem. You don't have a lease and you didn't serve them for me to terminate their tenancy. So you want them to move, you start a lawsuit and you ask the officer not to serve it because they already moved. So I can't order them to move, which would give you the authority to have the sheriff come take their stuff off the property. You stopped the lawsuit in the middle before we ever got to service. So the case is dismissed. You don't have a case. You can file a small claims action to recover money damages, but I don't have the authority to order removal of the motorhome or anything else.
But can I get rid of it?
Say that again?
Can I get rid of it?
Well, that's up to you. I'm not going to give you the court's authority to do it. They abandoned it. That's a decision you're going to have to make. I'm sure the township wants it off of there.
Yes, they do.
But it doesn't belong to you.
Pardon?
It does not belong to you.
No, it doesn't belong to me.
I wish you'd let the process server serve them so we would have a properly joined landlord-tenant case, but we don't.
But
so I'm not gonna.
Excuse me, but I'll tell you why I didn't. Because they ran my light bill. My light bill usually runs about $65. Right? It's just me that lives there. My light bill went up to like 300 and something. And all I asked them to do was pay my light bill. And they didn't do it for like 5 months. So now every month I'm paying $300 for a light bill, and I'm still getting served shut-off papers on it. And I thought if they get out of there, the light bill's not gonna go up anymore. But they left all the junk outside.
All right. Well, I would advise you to get out of the landlord-tenant business because there are certain rules you have to follow. So I don't know what to tell you. You got all their stuff. I don't have the authority to tell you what to do with it because you never served them with a lawsuit. So you can sue them for money damages. Let's say you have to hire somebody to move the motorhome. You can sue them for the cost of that, up to $7,000. But I don't have a lawsuit because they never got served with it. So I'm going to show this was dismissed. And
how long do I have to get rid of their stuff so I don't get in
I
trouble?
can't give you any legal advice. You let these people move a bunch of stuff onto your property without a lease. Then you never actually filed a landlord-tenant case against them because you didn't serve it with them. So this, like you stopped me in the grocery store and asked me for advice on what to do with this stuff. I don't have the authority to do that. So I would advise you stay in contact with the township zoning officials. If you move the stuff and destroy it, they may sue you for destroying their property. So you may start a small claims case against them, and then I can address this in the context of that.
All right, that's what I'll do, because they're not gonna file anything against me because they both got warrants. That's harder than not here today.
Yes, that's what I heard. Well, I was about to give you the relief you asked for till I realized they'd never been served. And the clerk told me that they weren't. So, all right, I wish you luck, but you might talk to them about filing a small claims action. Again, they have to be served with it. You can't file a small claims action unless you can file it, but you don't have a case unless they get served with it.
Well, I'll pay to serve that because I'll get money back.
Well, theoretically. All right, good luck, sir.
All right, well, thank you.
We have a blast from the past with Michael Spoolman here. We have Mr. Kanazuski here. We have Gateway Financial versus Melissa Jackson. Motion to set aside an installment payment order. Attorney Alex Kennett. What does the A stand for?
Adam.
Adam. This is a motion to set aside installment payments. Let me read it. Defendant was ordered to pay $150 bi-weekly starting 2/19/25. Defendant is behind $600 through July 9th. Plaintiff emailed and texted the defendant. Defendant made one payment of $150 on June 12th and no payments since, or no plan to get current. So they're asking to set aside this installment payment order so they could garnish wages. When I grant them, then a week later, the defendant files a request for an installment payment plan, and we end up chasing our tails around. So I've been just setting these for a hearing. Mr. Kanazuski, when was the last payment?
Your Honor, just recently made a payment of, well, July, she made a payment of 200. I guess I was going to say recently, but in July, I have her at about 9.5 payments behind now because she paid 200, not 150. So she kind of got a partial payment. So I guess we'd still be asking that it be set aside due to the fact that she's about $1,450 behind.
Ms. Rodriguez, what's your position?
Because I told them I was having problems with payments, and the job that I moved to Wisconsin to look for a better job that paid more. And when I got there, I was paying rent in Michigan, I was paying rent in Wisconsin, and then I had other bills. Then my car was having problems, so I took it to the mechanic, got it fixed. And then again, my car's transmission went out and I've been having problems. So since then, I've been like paying rides, like over 200 a week for rides, like taxi. So and basically my other bills and buying groceries for the week, I don't have the money. But then I moved back to Michigan Saturday because my mom died last Sunday. So I moved back here.
I'm sorry.
So thank you. So I'm gonna go back to my old job here.
Which was where?
Popeyes.
And where?
Sturgis, Michigan.
Mr. Kanazuski, would you be willing to discuss this with her in a breakout room?
Of course, Your Honor.
All right, let's see if we can get somewhere. I'm gonna put you in a breakout room so you can speak privately with him. Ms. Rodriguez, can you turn your camera on?
Yes, sir.
All right, click the button that says join. I'll set this aside for a moment. That's always the story. They have other legitimate financial problems and they forego this payment to make a rent payment or something, and then it snowballs. All right, we have another one of these. This is Discover Bank versus Brian Perez. Mr. Perez is here in the conference room at the courthouse. Attorney Michael Spoolman is here from his world headquarters on behalf of Buckles and Buckles. And this is a request for installment payments. The judgment entered January 1st of 2025. The defendant is requesting to pay $200 a month. The current debt is, I'm not sure what it is, close to $9,000. And again, I didn't want to grant that without some input from the plaintiff. Mr. Spoolman, good afternoon to you.
Good afternoon, Your Honor.
What's your position?
Well, Judge, it's basically as follows. It's basically what was set forth. The plaintiff filed a response to the request for installment payments, and it indicates in there that the current balance at the time they filed their objection, looks like that was dated August 25th here, 25, was $9,566. Their position, Judge, is basically that
there it is.
That since the defendant filed this, they're requesting $200 a month. They're saying, well, that'd take about 4 years or so to pay it off at that rate. And they're saying, well, they think that that's too long. They're asking that the motion for that amount be denied. And if the court does grant a motion for installments, that it be not less than $550 per month. That would provide the defendant with about $150 less than the defendant would have deducted from a pending wage garnishment. And that would allow payment of the balance outstanding on the judgment in only 1.5 years rather than 4 years. So that's what their position is at this time, Judge.
All right, Mr. Perez, you've offered $200 per month. That isn't enough for them on a debt of this size. They're asking for $550, which is probably more than you can afford. What's your position?
To be honest, I was paying on this, but then I took a job loss. I used to work at Jacob RV factory, and I was making pretty good money. And that's when I was attacking it. So I had to find another job, and it was Clayton Homes. But for this long period of time, it was the only what's the word? Reliable job I could find. And we were only working 3 days like that. And then I honestly been trying to attack it to the point where I get overwhelmed because just like I've been reading other cases or listening, like a bill comes up and then it's like my suspension goes out in my car. Unfortunately, I do have a Mercedes Benz, and I made that decision when I was younger and I had a better job. So the insurance is like 400. I would like to attract it. I like to be accountable that I used their credit card and it did help me when my work was low, because that's what I used the money for, to pay bills or groceries, or I would take out cash so I was able to pay my mortgage. So, but like how you say, I met up with Kelsey Community Credit Community, and we came up with this paperwork. I think I put it in with my motion, and yeah, like the most I have available at the end of the month, if I push it, is $360. That's why I was trying to make the motion so I don't feel overwhelmed. It's either.
Well, you won't like a garnishment much.
Right,
and
right.
you were robbing Peter to pay Paul, and the saying is living a champagne life on a beer budget, as my old probation officer, Steve Wilson, used to say. But they want $550, you want $350. I'm gonna order $400 a month.
$400 a month?
Yes.
And I have a question, like, Okay. And just,
I'm gonna start,
sorry about that, don't mean to be
go
disrespectful.
ahead.
I've never been in this situation, or never had family.
Well,
or-
you're doing the best you can, but you won't like a garnishment because you won't have enough money to eat or pay
Right.
your light bill.
I was just
But you
wondering
might
what
consider
happens,
getting a,
like, if I don't, like, can't meet those payments. I am trying to get a second job as well, like that.
I'd
And
get a different car for starters. I'm gonna start this December 1, 2025.
December 1, 2025.
Now, they also sent a nice order. I'm gonna use theirs. We can review this after 6 months, see what your situation is. Garnishee is ordered to discontinue the garnishment. Their information is on the order here. I've given you a little bit of grace time, the rest of October and all of November to get squared away to start to make this payment. Otherwise, they're going to garnish your wages and you're gonna not have enough money to put gas in your car. That's more than you want to pay, less than they want to accept, and certainly better than a garnishment. So as harsh as it is, it's less harsh than it would be. All right, Mr. Spolman, nice to see you again. Maybe you'll make it out to Centerville again one day. I've signed the order. If your client is dissatisfied, tell them that was the crazy judge in Centerville and they'll just have to live with it. But I think that's a fair outcome for both parties. And Mr. Perez, if you go out to the counter, they'll give you a copy of that order.
Thank you.
Okay, and Your Honor, thank you very much. I think the court has been trying to be very fair, and I understand that completely, and I appreciate that. Now, my thought, Judge, is if we're off the record here, just a couple of things I could mention.
We're on the record, so I don't know what to say, but we're off the record in that case.
Oh, okay. I just wanted to, my understanding is that the court will be leaving the bench at the end of this year.
No, the end of next year. I got 2026.
Oh, okay. Okay. I was thinking that it was going to be at the end of December here, Your Honor, and I was
a lot of people think that, but unless some catastrophe hits, I plan to be here through the rest of 2026.
Well, that's
Mr.
great,
Thornton
Judge.
and Mr. They're both grimacing, but yeah, they're stuck with me for one more year.
Well, the reason I say that, Judge, is I wanted to try and get down there and say hello here before you leave the bench, and I was afraid if that doesn't opportunity didn't present itself to wish you Godspeed. But Lord willing, and the creek don't rise, I'll be able to do that in person before you do so.
All right, thank you. I'll see you next year.
Okay, thank you, Judge. Have a good day. Bye-bye.
All right, Ms. Rodriguez is back. Mr. Kanazuski and Ms. Rodriguez were placed in a breakout room to at least engage in some discussion. Her tale was the same as it almost always is. People have other financial hardships. The creek rises, the car breaks. There are other problems. Mr. Kanazuski, did you get to any middle ground here?
Well, Your Honor, we did have an opportunity to speak. There is not a current garnishment in place, nor is she currently working. She just intends on getting a job or getting her job back in Sturgis. I would ask that the payment order be set aside. However, I did advise her to contact me or my client prior to, if she gets accepted at her job, prior to getting paid and prior to a garnishment, being issued. I said to call, and we habitually and routinely, work out reduced garns. We work out informal payment arrangements, although she'd have to provide her pay stubs, etc. But at this point, I just asked that the payment order be set aside. She doesn't have the ability to pay, nor is she working, nor is there a garnishment in place.
All right. The motion is granted and writ of periodic garnishment may be issued. Defendant not presently employed. Did you understand what he said, Ms. Rodriguez? If you do get employment, contact their office and at that point, see if you can set up some sort of payment agreement.
Yes, Your Honor.
Okay. Did you get her current address?
Yeah, it's the same one that's on my,
Oh, back at the Main Street address?
Yes.
All right, very good. All right, hopefully you'll get employed. You win the lottery, you can pay this debt off and get on with your own life.
Thank you, Judge.
All right, thank you all for your patience. Thank you.
Thank you.